Let me introduce this piece by kind of telling you where it started. It started with a question about this doctrine of unconstitutional conditions, which led me to a tentative idea / title, and everything went from there. So this is kind of working backwards from the normal approach where you start with an idea, go through the various inquiry, and then ultimately come out with a title. Title came first this time, and it was sort of a challenge for me. Is there a way to think about this problem through the lens of the text of the Constitution? And if so, what, if anything, can that tell us? So the question, let's start there. And the question, of course, swirls around this idea of unconstitutional conditions. Now, I'm sure most of you know when we refer to unconstitutional conditions in the constitutional context, we generally refer to this idea that government actors are limited in their ability to insist upon a surrender of constitutional rights as a condition of obtaining access to certain government-provided benefits, even in those circumstances where the government is free to withhold access to those benefits entirely, right? Now, most people think of this as kind of a conundrum, right? You have a constitutional right that an individual is free to waive, right? They don't have to insist upon it. They can allow the government to violate their rights if they wish. You have a government option, government benefit that the government is not obligated to provide. They can choose to give it. They can choose to withhold it, right? So we have this overlapping domain of permissions. Seemingly, this would present kind of opportunities for free exchange, and yet we have this intuition reflected in doctrine that there should be limits on this ability to impose these kinds of conditions in certain contexts, right? Often kind of presented in this very simple way that, it's impermissible to do something by indirection that it would be permissible for the government to do directly, right? Now, of course, stated in that way, that is a totally misunderstanding of how the unconstitutional conditions doctrine works, because the government is all the time permitted to insist upon surrenders of rights as a condition of obtaining access to certain kinds of important benefits. So, for example, federal employees can be limited in their ability to engage in partisan political campaign activity, notwithstanding their First Amendment rights. Recipients of state-provided welfare benefits can be forced to submit to in-home inspections as a condition of continued access to the welfare benefits. Criminal defendants are routinely offered the opportunity to obtain a lessened criminal sentence if they forego many of their constitutionally secured rights to a jury trial, to confront witnesses against them, etc., as part of the plea bargaining process. But there are times when the doctrine does limit the government in this way. For example, a state cannot condition access to tax benefits on recipients' willingness to pledge a loyalty oath in most circumstances. State can't limit welfare benefits to long-time residents in a way that penalizes newly arrived entrants. And state regulatory authorities have been held not to be able to insist on surrender of an unconnected parcel of property as a condition of obtaining certain kinds of development rights, right? So we have this mismatch, this kind of cluster of rules that are kind of hard to collate, hard to rationalize. The doctrine is widely regarded as somewhat incoherent. Some of the more colorful descriptions I have in the paper described as, among other things, a mess, a quagmire, an enigma, a minefield, and my personal favorite, an intellectual and doctrinal swamp, right? So that's my entry point here. And most of the proposed answers and approaches to dealing with this issue are kind of overtly functionalist in nature, right? Let's try to figure out what the broad purposes of the Constitution are, or of constitutional rights are, and let's see if we can come up with some frameworks that will make the overall functioning better without much guidance or limitation or constraint by the constitutional text or the original understanding. And I tend to kind of start from a different set of intuitions with regard to these kinds of questions, right? I kind of want some rules, right? And I want my rules to kind of cohere in some way reasonably closely with what I can figure out about the constitutional text. So that was the challenge I set to myself, right? Is there some way, working within the framework of the constitutional text, that I can find something to say that might inform this doctrine of unconstitutional conditions, right? And when I started this project, I really didn't have many clear answers, right? I didn't know what I was going to come up with. And it took a lot of kind of thinking and trying to figure out what's going on in this doctrine before I came to some ideas. And at a certain point, I did come to some conclusions that maybe the text actually does have some important things to tell us, right? So first, important move to make is to note a distinction between two ways in which the Constitution limits government, one by enumerating individual rights, and two by imposing structural limitations on government actors. Let me start with individual rights. Now, if we read through the Bill of Rights and other important provisions of the Constitution dealing with individual liberties, many of them don't say all that much overtly about consent, waiver, or similar concepts. Now, some do. The Third Amendment, for example, refers to the consent of the owner as a stricture on the quartering of troops in private homes, but most of them do not have those overt language. So the first question is just, where does this idea of waiver come from? Where does this intuition that we can waive rights come from? Now, going back to the history, right, I have to understand the text in context, look at widely accepted interpretive principles, and going back, and I found one that kind of informs that idea, right? This old Latin idea, quilibet potest renunciare juri pro se introducto. My apologies to any native Latin speakers if I butchered that pronunciation. I refer to it in the piece, and I'll refer to it here as the pro se introducto principle, because those are the words I can pronounce. And it's this very old idea going back to the 17th century and earlier that one who is benefited by a legal right or privilege should have the option of foregoing that benefit if they find it would be more conducive to their overall well-being, right? Just ordinary idea of waiver, right? And it's my view of the early evidence of the post-ratification process, both in the regard to US federal rights and with regard to state constitutions, is that this was generally the presumption that was applied to most individual liberties, right? Not all, perhaps. There's some questions about inalienability with regard to particular kinds of rights, but many were assumed to be waivable in this way. All right, now we have a waiver principle, allows individuals to decide the government can act towards them in certain ways. What are the limits on that principle? Well, it requires consent. So we go back and look at the relevant interpretive period, relevant framework. What are the limits on consent as a doctrine of legal binding? Here I looked to various contract principles and related doctrines, notably the doctrine of duress. Doctrine of duress provided a limit on the binding nature of a contract where illegal action was present and where the duress involved some meaningful degree of compulsive force. Very similar to the doctrine of duress today, although somewhat more demanding, including limiting its operation to actually illegal conduct rather than simply immoral or unreasonable conduct as permissible under some rules today. All right? Now, if we define it by illegality, then we have a new conundrum, because that is inconsistent with the way we normally think of the unconstitutional conditions doctrine. The unconstitutional conditions doctrine is normally presumed to apply only to things the government is allowed to do, right? Now, I think there is a misleading nature in that because I think there are further constraints, particularly regarding the Constitution's equality guarantees. The equality guarantees limit the distribution of various rights and privileges, right? It limits the way government can distinguish among individuals. And most unconstitutional conditions questions have within them an embedded equality question, right? The comparison between the group that surrenders their rights and receives the benefits versus those who refuse to do so and are burdened by the government, the withholding of the government benefit. So I think equality is a meaningful principle in the unconstitutional conditions doctrine, and it maps to certain ways we think about the doctrine in the modern era, right? Particularly the requirement of germaneness, a requirement that a condition be germane to the principle, that a condition be germane to the benefit being offered. Now, I don't think equality is a total answer to this. There are other applications and other issues where other rights can block a purported condition. But I think starting with the question of whether it is constitutionally permitted or not is the right starting point. Now, I want to contrast that in the remaining time with another set of restrictions, those involving limitations on structural principles, particularly structural principles of federalism. In various areas, including conditional spending, the Supreme Court has held that very similar principles, including germaneness and the idea of coercion, block the ability of the government to condition access to states on certain kinds of benefits. Now, I think there are important limitations and constraints on such conditional spending by government, particularly the requirement of no independent constitutional federal government can insist on unconstitutional action by the states as a condition of certain kind of benefits. And there may be an argument for something like a germaneness principle. But that's going to depend on the actual, sorry, I'm over my time. It's going to depend on the actual content of the, notwithstanding my article, I'm going with the spirit rather than the letter. That will depend on the actual content of the right being exercised by the government. Particularly with regard to the spending clause, we have different theories of what provision justifies those spending powers. We'll have to look at the original meaning of each of those to figure out to what extent germaneness is a principle. But I'm most skeptical of the idea of coercion as a freestanding barrier to conditional government offers with regard to the states. And the reason is very simple. Because structural limits are not waivable in the same way as are individual liberties. Usually the federal government and the states cannot negotiate with themselves, cannot engage in a contract or treaty to renegotiate the lines of their respective sovereignty. States are free to act on their own matters of internal governance. The federal government is often free to provide or withhold a benefit to the states. And just as sovereigns on the international plane can condition access to their benefits or privileges when they're dealing with one another, I think similar principles can apply by analogy in the federalism context. So I'm much, much more skeptical of coercion as a freestanding limit on government power in that regard. Much more to say, but I will leave it there and look forward to your questions. Thank you so much.
This is a great paper. I'm going to spend most of my time talking about federalism. Here's the reason why I'm going to talk most about federalism. It's that I think that the text, even glossed by original methods, doesn't do very much work in the individual rights area. Most of the ideas that Ryan comes up with they're all ideas that non-originalists have come up with. And so it's not clear that the text is telling you, it's not clear that the resort to the text is telling you anything new. In fact, I think the whole doctrine is completely non-originalist. I think it's all, or it's construction, as opposed to just can be derived from the text. But in the federalism area, it's different, and I want to talk a little bit about that. By the way, there is one example in which, and you only mention in a footnote, where it really matters, the pro se introducto doctrine really matters. So in Article 3, you guys know, Article 3, Section 2, Clause 2, it says the trial of all crimes, except in cases of impeachment, shall be by jury. That's a rule. It's not a right. It's not a right of jury trial. It's a rule. Now, if, in fact, we just read the text right plainly, it would suggest that you could never waive your right to a jury trial in a federal case. But that has certainly not been the practice, and it's not been the practice for a very long time. You could argue the Sixth Amendment basically repeals that, but it would be very weird that the Bill of Rights repealed something like that. So that pro se introducto canon actually helps you with that. It actually shows you why, in fact, you can have federal bench trials. So you mentioned that buried in a footnote, but actually that's where the original meaning of the text, glossed by original legal methods, actually makes a difference. But the really interesting parts of this article are in part 3 on the federalism stuff. And and Ryan is taking, I think, a really interesting position, which is not one held by lots of people, which is that the whole coercion analysis coming from Stewart Machine Company and then in Sibelius is wrong, and that we should analogize states to like nations, and under the law of nations, you can put other nations under a situation of compulsion where they have no choice but to accept. That's okay. And you can even put them under situations of duress where the act is unlawful. I mean, under the law of nations, otherwise you couldn't sign treaties, right? All right, so his view is an incredibly broad power of the federal government to impose various conditions on the states. That is unusual. I mean, this is what's really interesting about this piece. Let me say something about my views about that. The first thing I wanted to say, because I couldn't resist, we talked about the spending power yesterday. I have a view about it, which I guess is no longer popular, which is that the source of the spending power is the words provide for in the General Welfare Clause. We should call it the provide for clause. And because the word provide means supply, and is that supply funds, and that in British parliamentary practice, when the Parliament refuses to provide funds for the Crown's ministers, that's called a loss of supply. So provide for is in fact the source of Congress's power, the spending power. It should be called the provide for clause. So that's important because, I mean, Chris will disagree with me. I know, that's fine. I love you, man. But anyway, provide for, the reason why it should be there and not the property clause is we want a general welfare restraint. That is to say, you have to provide for the general welfare, whereas a property clause, there's no general welfare component. That's my hobby horse. Mm-hmm. So one of the reasons why you get these doctrines, which I think, I agree with you, don't have a basis in the text, even glossed by original methods, is because they're all living constitutionalist doctrines. That is, Stewart Machine Company is a living constitutionalist doctrine caused by the growth of the federal government, its power and its ability to do things, and the growth of the use of spending power to get the states to engage in cooperative federalism. And so in response to a transformation from the understanding of the founding period, you get this new doctrine designed to protect state interests. It's like a Lessig-like translation. And I think that's what it is. I think that's why you can't get it from the text. Similarly, I think that the Prince doctrine is not grounded in originalism. I think the Prince doctrine is basically also a response to the growth of federal power following the New Deal and cooperative federalism, where if you basically force the states to administer federal program after federal program after federal program, they don't have any money to basically administer their own programs. It's an unfunded mandate. And so that idea is an idea that arises post-New Deal. And so again, I think this is why you don't see it in the text. It's because it's really a response to changed circumstances that arise from the growth of the federal government. The last thing I'll say is that Sibelius itself rests upon a kind of a weird distinction, which I think is unjustified. So your view, which I think is correct, is that if the federal government says, here's some money, please spend it according to the way that we would like it spent, there is no coercion issue. There's no problem under constitutional doctrine. If I say, here's money for highway signs, this is what the sign should look like. If you don't want your signs to look like this, don't take the money. That doesn't raise any coercion problem. The coercion problem arises if I say, here's some money for this purpose, now I want you to do something for me on this issue. So here's money for highways, please change your law with regard to drinking. That's where the coercion issue arises. The only reason Sibelius comes out the way it does is because Chief Justice Roberts uses the Pennhurst doctrine to claim that the new Medicaid is not the same program as the old Medicaid. If they were the same program, there would be no coercion issue. And indeed, the Chief Justice said, look, if you got rid of old Medicaid tomorrow and created a new program called Old Plus New Medicaid and then gave the states a choice, there would be no coercion problem. But again, I think this doctrine is a living constitutional doctrine. It's a doctrine that's trying to deal with the fact that as a going concern, the federal government is changing its programs, the states may not be able to catch up, and it may produce burdens on states, and therefore to compensate for the change in the forms of governance, these doctrines emerge. Okay, that's all I wanted to say.
So thank you so much, Jack, for all of those comments. I think mostly in agreement. And I take the point that a lot of what I say with regard to the individual rights is not entirely novel and not entirely dependent upon the text. I think other scholars working in sort of the more modern context have noted some of these ideas, including the connection between equality and unconstitutional conditions. But there are competing models and competing kind of ideas out there. So I'm kind of staking a claim that the text reinforces some of those ideas and makes them a little more plausible. But yeah, no, I think totally many of the ideas I find in that area are much closer to both current doctrine and to current scholarship in the area. And I should also kind of just acknowledge that my observations here are not a panacea, right? They're not going to cure a lot of the confusion that we have in unconstitutional conditions doctrine, because equality is hard, right? We have disagreements about what equality requires, and there may often be kind of evidentiary problems to get at kind of whether similarly situated people are in fact being treated similarly. With regard to the spending issues and the federalism issues, I totally agree that I remain agnostic on the source. I think the choice between the general welfare taxation language or the property clause or the necessary and proper clause, which is the third option, obviously has important implications for how we think about particularly something like the germaneness requirement. I do think, however, under any of them, the anti-coercion principle is questionable. I think I largely agree with your characterization of Stuart Machine and later cases, including Sebelius, as more in the living constitution mode, kind of responding to the much different way in which the federal government looks today. And then you just will have a methodological argument between various sides about what the implications are for that for how we think about sexual restrictions. Prince, I think there is certainly a very plausible argument that too is to what extent that can be reconciled with the original meaning. The only point I will make on that is that even under there is a more plausible argument for Prince under original meaning, because ordering the officers or employees of another sovereign to do things was not something nations could not do on the international stage in the way they could kind of try to procure similar action by inducement, right? So I think you can get off the train, you could stay on the train till Prince and then get off at the coercion principle if you so choose. So I'll stop there.
Okay, great paper, Ryan. I really enjoyed it. I learned a lot from it. I found it interesting that you said you started with the title and then did the research, because I want to sort of echo and build on one of the things Jack said, which is kind of that I wonder if you should change the title, because I don't really think text is driving all that much of the analysis here. I think your analysis is more formalist than is typical in this area. But just for example, parts 2A and B you asked us to read, where you get this, this old Latin pro whatever, yeah. and common law duress principles. Those aren't derived from the constitutional text. Then part 2C, you say, but there is this equality constraint that comes from the Constitution's equality provisions. But I remember if it's a little section or footnote where you say, well, of course, originalists can't even agree on what actual textual provision of the 14th Amendment contains an equality guarantee, but we all do seem to agree that it's not actually the part of the 14th Amendment that textually mentions equality. I don't really view that as a particularly textual point. And then when you get part 3, where you're getting into the federalism stuff, you say, well, this equality analysis doesn't really come in here. But I'm wondering textually, first of all, the general welfare clause seems to imply a certain sort of uniformity and equal treatment of the states. And in the 19th century, there was some jurisprudence saying that the federal government couldn't spend to favor some states over others because it violates general welfare as a textual matter. And then there are other textual provisions of the federalism parts of the Constitution that require Congress to treat the states equally. You've got the port preference clause, the tax uniformity clause, the bankruptcy clause. So, I think to the extent that text is relevant, it seems to actually point in a somewhat different direction, which is not to question any of your conclusions. It is maybe just a question whether this is really a paper about text.
So you've got a big discussion of Nolan and essentially the germaneness approach in Nolan, but that's a regulatory takings case. And I think the original understanding of the Constitution is that there are no regulatory takings. So I mean, in some sense, this follows up on the kind of what's your text? Because you're dealing with a category where original understanding is basically irrelevant, and you're coming up with a limitation. Where does that come from?
It's a nice paper. I like the Law of Nations move. I think the move to say we need to think about this in different ways when we're talking about individuals and states is a good driving move through the whole thing. I want to raise a question about what you say on the state side about structural limitations. Right? When you say there are reasons to think that things are more waivable in the individual rights domain than they are in the structural limitations domain, because the paper seems to treat two different kinds of structural things the same for this purpose. Not in a worked out way, but like in its explanation. One is the kind of structural limitations that are stated as prohibitions on what the federal government can do. right? So like the federal government cannot unilaterally dismember a state, for example, right? The other is the effect of the system of enumerated powers, right? Which according to the prevailing view acts as a kind of structural limitation, right? But those two things I think are very different here, right? In the following way. You would need to work around if it were possible to work around the first kind of structural limitation through state waiver, that would be analogous to what's happening in the individual context. And that's the thing that you, I think, say you can't do, right, in the federalism context. And you're on reasonable ground there. But the enumerated powers are not prohibitions, right? They're empowerments, right? And the federal government's choice to use A rather than B rather than C maybe shouldn't be conceptualized as trying to do indirectly what it can't do directly. It's simply doing a thing that's permitted, right? To get to the idea that it can't do, that there's something suspect in a workaroundy kind of way about using one enumerated power rather than another, you have to have the idea that there's a prohibition somewhere that's being worked around, right? And that, I think you don't have if all you have is the text of the enumerated powers.
Thank you so much for all of those comments. Tom, let me start with you. I think this has been one of the more frequent comments I've gotten on should I change the title, which is maybe why I started the way I did, because I'm a little defensive about it, because I really like the title. I do think that the text is supplying the overall framework, at least in the way I think I'm thinking about the text. I mean, the sort of mental model I have here. Now, of course, I'm reading text in context, as all originalists are supposed to do, right? And that includes background factors, and many, maybe not everyone agrees that those background factors include things like widely accepted interpretive principles, particularly legal maxims. That's a little more controversial. We're getting maybe into the original public meaning versus the original methods meaning or the original law meaning. But I think there is a strong argument that those kinds of principles should play a role. And then getting to your other points and bringing in Dean Trainor's points as well, I think there is a challenge and sort of a dodge I have to use to some extent in this piece is because the unconstitutional conditions doctrine extends to so much and so many contexts, it can require not only analyzing each and every constitutional provision potentially, but each application of each constitutional provision. So I'm kind of biting off a big project here, which is why I think I need to some extent, gloss a little bit, because it can easily get bogged down in interpretive controversies about particular provisions and what they mean and how they apply, right? Does something like the Fifth Amendment takings clause apply to regulatory takings or not? And I want to try to skirt at some level above those nuances to some degree, because I think that even if you have a classic taking, even if you change the facts of Nolan, for example, and we're taking it out of the regulatory takings, and we use the same thing with a physical taking, then I think the principles I have, the ideas or intuitions I have about waiver and limitation and duress and all of those principles still apply. So even if you disagree with the way that particular right is being deployed in the case, whether or not the waiver is valid and in what circumstances the waiver should be permissible or the imposition of the condition should be permissible, I think the text can speak to that question even if the underlying right is being misinterpreted. Now the equality points, the which provision actually grounds equality, I think is more significant. I think most will agree that at least somewhere buried in the 14th Amendment there will be equality restrictions with regard to the states, right? Equal Protection Clause, obviously, Privileges and Immunities Clause, according to many people, the State Citizenship Clause, according to some, right? So there's fun debates to have within that, right? More controversial with regard regard to the federal government, I at least think that the Citizenship Clause of the 14th Amendment provides a strong grounding for that principle, as do others. There are other arguments that can be made in similar regards, but if I lose you there, right, if I lose you on there's an equality guarantee, the consequence, the payoff is going to be there's going to be a lot less room for the unconstitutional conditions doctrine to operate because a lot less things will be unconstitutional for the government to threaten. Richard, I take the thank you for the point about the differing significance of the structural prohibitions versus the significance of structural enumeration. I take the point, to some extent I think this is again a interpretive controversy about particular provisions and a very big controversy about the significance of enumeration and how we think about it. I know you and others have your views, and again, if I'm wrong on that, then again, it's going to have different implications for how we think of. Finally, just on the general welfare point, do we need to treat all the states the same? There may be an equality principle with regard to the states, but again, I don't think it matters as much because the reason inequality matters with regard to individuals is because we care about coercion, we care about duress, we care about whether they are voluntarily consenting to waive their rights or they're being forced to do so. Whereas with regard to states, I don't think those considerations matter nearly as much because I don't see state-federal boundaries susceptible to renegotiation in the same way.
Thank you for the paper, Ryan. It stimulated a lot of thought. So I think that there's, this echoes, I think, Tom Colby's paper, but maybe putting it in a different way. So your project is to articulate sort of a textualist approach to unconstitutional conditions, but that approach is situated in a constitutional world in which we have not taken a textualist approach to everything else. So if you try to impose a textualist regime on unconstitutional conditions, but the underlying substantive constitutional law on most of these topics is not itself textualist, you run into this problem sort of the second best, right? In the first best originalist world, the substantive law and the unconstitutional conditions law, they're all textualist. But in a second best world, it may be that a textualist approach to unconstitutional conditions systematically moves outcomes even further away from the outcomes we would get under the original meaning of all the rest of the Constitution. So my suggestion to you is that you take that problem head on. And I think if you use this problem in part as a framing device that is laying out, sort of the ways in which many of the unconstitutional conditions doctrines are compensating adjustments for things that have gone on the substance of the particular provisions, that the picture would get much clearer than it is now. So I really like this paper, but I did have trouble understanding it. I think I'm not the only one. And I think that some of the trouble in understanding the paper is a function of this sort of mix and match approach to textualism on some things and not on others.
It will.
So I'm curious about sort of the heart of one of your examples of waiving rights, which is this idea that it violates equality for the equality principles for the government to try to induce people into a waiver, right? So one of the examples is requiring all applicants for welfare benefits to sign a blanket waiver of their Fourth Amendment rights against unreasonable warrantless searches. And the idea is this violates equality principles because the government has no actual reason for making this demand of poor people who need welfare as opposed to other people. The only reason it's doing that is because the people who need welfare are sort of in a weaker position and need something the government has, so they're more vulnerable, more likely to agree to the waiver that other people won't agree to. And that sort of like replicates this L. Haig and other people like distinction about what it is that makes something a coercive threat. But I don't understand what it has to do with equality. I don't understand why the government isn't allowed to say, we have a reason for targeting the people who are getting welfare benefits, which is we think they might say yes. Like, if we could get other people to waive their rights too, we would. But this is something we want, something we can only attain by consent. And so we're targeting the people who we think we might be able to buy. And in the same way that, like, when the government goes out to try to buy parcels of land and get people to waive their right to property, it might, try to induce the people who it thinks are most likely willing to sell. And I get the general intuition that comes from non-textualist unconstitutional conditions doctrine about which of those we might be worried about for other normative reasons. But I don't get the formalist intuition about why it violates equality for the government to target people who have something it wants.
Okay, so I guess I want to throw out another way of thinking about unconstitutional conditions and just get your reaction to it, Probably just say, well, that's idiotic. So let's say for a second that you thought there was a police power. I'm somewhat skeptical of the police power in the early years. But let's say, it's a privileges or immunities sort of issue post 14th Amendment. I'm not so skeptical of a police power there. I think some good evidence for that. So then what the government does is then limited by the police power. This idea that they can just do all this stuff. No. It's got to be for certain purposes, legitimate purposes, and it's got to be reasonable towards those purposes. So let's imagine where we're talking about plea bargaining type situation. And the government says, okay, well, 50 years if you do a trial, but, a year if you plead. So it might be legitimate for the government to want to avoid the trial in order to save money. It's not legitimate for the government to get somebody to plead guilty who's not actually guilty, right? And so whether you view that as the end or you view that as a reasonable means towards the end, you could view it either way, I suppose. And so you might say, okay, 5 years if you don't plead, and 4 years if you plead. You saved us, a year's worth the money that we're saving. So I guess I want to just throw that out as if one believed in the police power, could that impose a very significant constraint on an unconstitutional conditions constraint? Did you ever in your reading of cases get anything from let's say the 19th century that looked at things along those lines? So that's my question.
So thank you so much for all of those questions. I think those are all really helpful. So Larry, I think it's a great comment and something really important to think about, right? How we put together, it's the general, the big problem of the second best in originalism, right? Does it make sense to be a little bit originalist, or is it only going to make sense if we kind of have the full functioning working system going together? And I think to some extent the problem might be informed by how one thinks about the mix between text and function, and something like spirit, to kind of invoke the idea that Sai sort of told us about yesterday. I think the extreme textualists, who are very skeptical of legislative intent and similar things, will be on the side of, well, we just have a set of compromises reflected in the document, and we can't impute to those particular compromises broader purposes or outcomes, and if you view the Constitution in that way, it might lead to some, general skepticism of, constitutional purpose in general, or more abstractable purposes raised up from the details of particular compromises. And I think then we have a real problem if we think that the spirit method was the original way we should have thought about these issues. Should we then just abandon spirit, or should we expect official interpreters to imagine there is some general purpose, even if there may be no actual there? I think it's an important question. It's not one, again, I'm not sort of taking head on in this piece, this version of the piece, but it may be something I need to, either in this or a future project, take on a little more directly, right? And then, the other response to that is, maybe the better approach is just to try to move everything in the more textualist directive or more originalist direction, and then it's just a question of, when you start, where you start, and how thoroughly you progress. I think the unconstitutional conditions doctrine might be a okay place to start because just the current doctrine doesn't have that much coherence or predictability or other kind of advantages, so you're not kind of unsettling that much in terms of a sort of coherent framework. So the welfare recipient example, sort of the equality concern that I'm focusing on there is not so much between sort of welfare recipients and non-welfare recipients, other members of the public, right? It's between those individuals who accept the government's condition and agree to the search of their premises versus those who refuse to do so, right? Now, one concern you could imagine being expressed in that equality domain is that the government wants to provide welfare benefits for everybody, right? And if they're not able to impose this condition, they will just, give everyone welfare benefits, but they are, hey, let's go ahead and throw in some conditions on top of that, and that will get a lot more people to cooperate with our searches and open their doors, and won't that be great, right? Now, unless the government has a reason for drawing that distinction apart from the desire to induce that behavioral change, I think there's an argument that those two groups are similarly situated with respect to the government's general reason for providing welfare benefits, right? Government wants to secure every individual in terms of their basic human needs. And then if you buy that, right, if you're willing to go that far, then if you're drawing the distinction between those two otherwise similarly situated groups, you're saying we will treat you equally, essentially, if you comply with our condition. And that, I think, is very close to just kind of taking someone's property, right, something they're already entitled to, and saying, I'll give it back to you if you agree to my condition, right? And then again, we can get into that argument about, is that the right way to think about equality as applied to this particular context, right? And, maybe the argument might be that, no, the government doesn't want to give this. Maybe they only will give this money, right? Maybe they are trying to just purchase, right? If it's an outright purchase, we'll just give you money, no matter your income, anything else. We will give you $500 if you agree to sign over your search rights, right? Then we might have a different discussion about, whether that is a similar kind of idea, right? So the kind of provisional counterfactual test I kind of sketch out in the piece is, would the government do this even if it knew for certain that it would not induce any behavioral changes on the part of targeted recipients, right? If the answer to that question is yes, right, they would still make the same distinction, then I think there is a better argument for it to be based on a real similarity between the groups rather than a desire to induce an underlying change. But we can maybe talk through that a little later. Michael, I think the police power point, I think, is that would be another way to think about the issue and the problem, right? We would have to, for that to work at the federal level, you would have to accept something like a general police power for the federal government, and sort of, or I guess you would sort of ask to what extent the enumerated powers map onto the conception of the police powers at the state level. the state level, maybe you could get there in a similar way. I did not come across that concept very much in the early portion of the history. I probably should go back and look a little more carefully at the later 19th century when the police power became a more prominent kind of doctrine in terms of the concept for organizing and limiting government. Maybe there will be some more to find there, but it's a different way of thinking about the issue that's kind of a little less text-centered.
All right, thanks so much. So I have two comments. One is on inalienable rights, and I just think this is totally a red herring. An inalienable right is a thing that you physically lack the capacity to give up, or a thing that upon entering into a social contract, individuals would have no reason to grant the government any authority to regulate whatsoever. And there might be things like your ability to engage in free thought that are inalienable, and yet when you translate it into a condition on a public benefit, it just doesn't obtain at all. So like I have no ability to not have heretical beliefs, and yet that gives me no authority to exercise governmental power at the founding. Like, excluding atheists would have been very straightforward because they couldn't even swear an oath that would be necessary to serve in public office. And then in thinking about not inalienable rights, but other rights that might be recognized by the Bill of Rights, here I want to double down on what Mike said, but from a different direction. So, maybe I'm wrong, but if I'm right, the First Amendment, say, recognizes a common law right and a natural right. The common law right, you'd have to ground somehow as a right that includes a right against the selective receipt of benefits, which, good luck making the argument. Maybe you can, but I think that's going to be hard to show in history. And then the natural right, you have no right to any sort of governmental largesse in the state of nature. That's just a bizarre idea. And so I think really what you're getting at when thinking about the general restrictions on the reasons that the government can condition public benefits is a social contractarian logic that the government is organized for certain purposes and in the nature of things or in the sort of process of reasoning by which we think about what the basic powers of the government are and the limits on those powers, we find that there are certain rationales that are legitimate and certain rationales that are illegitimate. So it's much like Mike's comment, except for my point is not police powers, but general social contractarian limits. And that makes me kind of skeptical that this is all about the text, especially of the First Amendment, as opposed to a kind of background social contractarian principle that's operative here. Thanks.
Steve, thanks so much. This is sort of a friendly amendment. I don't think I saw in the paper a discussion of sort of what necessary and proper really is. And so I think that would be really helpful. In particular, if necessary and proper powers are sort of incidental powers, there are things that come along with the territory, or Sam Bray's Hendiadys papers, there are things proper to the particular powers that are conveyed. That might be a good way of cashing out a lot of the germaneness test's sort of strange aspects, because it's the same sort of wishy-washy concept that's going on there. So, as I understand the Engdahl argument, it's been a long time since I read it, sort of Hamilton's spending power is a power to spend money on stuff, but that doesn't convey a general power to regulate the stuff spent on. So Congress could appropriate money for the Cumberland Road, but that doesn't mean it can like set a speed limit on the Cumberland Road or something, or as might be salient now, maybe Congress could apportion money for abortion clinics in all 50 states, but that doesn't mean it can necessarily override a state rule against abortion in one of those clinics. So that would be a much more contentious question of whether it could do so. On the other hand, there are some kinds of powers that are incidental to spending the money. For instance, this is the kind of sign we want, like in Jack's example. Sort of like, that's what we're buying. We don't want this money stolen. Like, there are lots of powers you would have just by virtue of spending the money. And I wonder if that in many ways tracks the germaneness test. so that sort of it's a germane, if something is germane to what you're spending the money on, then yeah, you can regulate it because that's the thing that you want from this program. Whereas if you're attaching some other thing, you just lack any incidental power to regulate that other thing. And that gives us a language for why you can't attach the condition, which doesn't require that the person be sort of overwhelmed by the amazing amount of money they would get. I mean, if they say, you get 1 cent less for the Cumberland Road if you permit abortion in your state, or something like that, that would be just as much of an unconstitutional condition, even though no one would really care much about losing a penny.
Thanks for the paper, Ryan. I admire it because this is a very difficult topic to take on, especially from a textualist and originalist perspective, and I thought there was a lot of sophisticated analysis here that was illuminating. My question is probably in the same vein as Tom's question, though I'm going to ask it less from a skeptical perspective, more just like a clarifying question for you, so that I understand your argument better. So as I understand your argument in part 2 on the individual rights front, you are deriving this duress conception from background principles at the founding, and that's rooted in the text. In your view, let's just grant that as being a legitimate move, and I think that's a plausible move as a textualist. And that sets up the problem in part 2C of, okay, well, if duress is about unlawful action, what are the sources of the unlawfulness here, so it's not just an empty set, right? And you march through potential sources of unlawfulness. And it seems to me that the equality source would be the 14th Amendment, including against the federal government, because, as you point out, relying on your own scholarship on the Citizenship Clause, it seems much more likely that against the federal government that equality guarantee comes from the 14th, right, than from the 5th. Then part 2C3 and C4, you consider alternative, non-equality-based views of unlawfulness. But I didn't see very much textual originalist analysis there under C3 or C4, except for a stray kind of citation to Judd and his article. So the clarifying question is this. Let me just grant your duress move. Let me grant the equality principle as being rooted in the 14th Amendment and rooted against the federal government in the 14th Amendment. Because I didn't see much textualist originalist analysis in C3 or C4, is it your view that prior to 1868, from a textualist and originalist point of view, the unconstitutional conditions doctrine was effectively a null set?
Thank you so much for those comments. John, I think when I'm referring to inalienable rights in this context, I mean, the inalienable may be a perhaps misnomer or confused terminology. I'm not referring there necessarily to inalienable natural rights. I'm referring to things that are not kind of alienable in the technical sense, in the terms of you can't exchange them for something else, you can't give them away, you don't have the power to waive. So that's the only sense in which I'm using inalienable there. And I think if you understand it in that way, I think it's quite plausible there are things you can't do by consent with regard to the government, right? You can't consent your way into Article 3 jurisdiction in a federal court. Jack mentioned the example of the jury trial provision of Article 3. That trial by jury in the federal court shall be trial of crimes in the federal court shall be by jury, right? Doesn't signal directly that there is any right to waive it, unlike the Sixth Amendment, which does suggest potential waivability, right? So if you can see kind of the textual distinction there, which Akhil Amar and others have kind of pointed out. So that's the only kind of sense in which I'm using inalienable there, but I take the point. Maybe it was a poorly chosen word. Just non-waivable rights is what I have in mind there. And then with regard to kind of the broader principle of the social contract, I think there is a view in there that is kind of bound up as an overall background principle, and then there is the more specific question of how that gets imported into or undergirds particular enumerated liberties, right? Things that are written down, right? You can think about social contractarianism as informing government in general or relations among people in a polity in general. but you can also think about understandings of social contractarianism to the extent they are embodied in particular rights or for particular purposes. And my citation to your piece with regard to the First Amendment in that portion is to signal that maybe there, without kind of drilling down, and this will get to Joel's point, which I'll go to next, there just might be an argument along those lines that if we dig further, we could maybe find a originalist textualist grounding for. And this gets to the part B and C point, or two C points, right, about, all these provisions. Now I'm talking about mostly in terms of more their modern doctrine than their original meaning. And the point of that section and discussion is not so much to make a strong claim that any of the particular rights I'm discussing in that section are, that the way I'm describing them in there is the right way to think about those actual rights in operation, but just to make the broader point that there may be things other than equality that will block a conditional offer by the government that will constrain the action, right? And this is important because some of them look on their face a lot like equality, right? Like Sherbert versus Werner or Shapiro versus Thompson, right? Just take Shapiro versus Thompson as an example, right? You have individuals from out of state moving into a state, being denied welfare based on their recent arrival, right? There's an equality dimension there between the comparison between the newly arrived citizens and the longtime residents, right? But if you think about it in the equality framework that I'm talking about in the preceding section, there's no equality problem because the people who exercise their right to travel are being treated the exact same way as everyone who remained back in their native state, right? They're not getting any benefits from the local government, right? If we think of those as the same problem, we think of coercion or something similar as the uniting factor, we're just not going to make sense of those because we're dealing with different kinds of concerns. I think that Shapiro versus Thompson in similar cases might be much more plausibly explained by something like the right to travel, right? Then we would have to find a grounding for that, right? Is that the Privileges or Immunities Clause? Is it Article 4, right? Is it something else, right? So, but I think you have to understand the analytical structure of the problem before you can kind of get a diagnosis. So I'm not wedded to any of the particular examples there, except to the extent they help illustrate the underlying point. With regard to prior to 1868, was this all a null set? I don't think necessarily, because you still had, with regard to state governments, I think you would have restrictions like the contracts clause that might be a limitation on government, right? But then you sort of, have more trouble finding the offsetting limitation on state government, right? You would then probably have to rely on something like state law, right? Then like the police power or something similar concept or social contract as your restraint on your ability to condition, because the federal government didn't imply any kind of general equality obligation on the states, right? So I'm not sure there would be that kind of restriction on conditional offers by the states, right? And again, if equality is our criteria, probably similar answer with regard to the federal government, although people like Gary Lawson and others have made the argument that the necessary and proper clause or just the overall structure of the government imposes some kind of general equality norm. Again, for purposes of this piece, I'm trying to be kind of as agnostic as I can on kind of all of those broader claims. And then Steve, I totally agree with regard to the necessary and proper clause in connection to germaneness, right? This is why it matters which power you are grounding the spending doctrine under, right? If it's necessary and proper, that would support a very robust germaneness requirement, right? If it's the taxation provision, the general welfare proviso, right, then it's not so much tied to the particular program, it just has to be for the public good in general, right? If it's property clause, nothing. You can do anything related or unrelated, right? So that's why the choice of those frameworks matters.
So, fantastic paper. I wanted to briefly push back on this provide and support ditty from Jack. And of course, this might bring back great memories of the Dianne Feinstein and Justice Barrett bit, where she asked Justice Barrett about Mike's view of, and Madison's view of the spending, the lack of a spending power. I agree this should be called the provide provisions power, provide power, but it seems like that supports Madison in light of Article 8 of the Articles of Confederation. All charges of war and all our expenses that shall be incurred for the common defense or general welfare and allowed by the United States and Congress assembled shall be defrayed out of a common treasury, which shall be supplied by the states. And of course, this is the whole system that has to get replaced. Clauses 12 and 13 to raise and support armies, to provide and maintain a navy. The thing is, if the Articles of Confederation don't provide a general power to promote to spend for the general welfare, this English law background, you have to have a separate power to actually engage in the war. This is just providing and supplying and getting the money for stuff that you have an independent power to do, a la Madison. So anyway, I just wanted to raise that flag yet one more time. So.
My question, kind of dovetailing on Steve's question, is about the necessary and proper clause, but also the 10th Amendment, and what role the 10th Amendment might play in this analysis. You mentioned Lopez and Prince, but not necessarily grappling with whether this could go from a spending power necessary and proper, incidental power to necessary and proper, into transgressing maybe on the reserve powers of the states. And so I'm wondering if there's anything for the idea that you can spend for the general welfare and common defense, but then if you're trying to coerce the state into doing something under that spending power, now we're in necessary and proper land, and if it might be improper to infringe, depending on how it might infringe on the states in certain ways. So if you're infringing on the states' traditional prerogatives, maybe over roads or over certain things within their territories, if there might be some kind of constraint from necessary and proper in the 10th Amendment with respect to how much pressure they can put on the states, and if there'll be some kind of heightened analysis in that regard. So sort of speaking to the impact that the 10th Amendment might have on this analysis, if any.
Thank you for the paper, Ryan. I think you're grappling with a really important problem, and I just want to raise a question for you, a case that you didn't discuss, and maybe another similar hypothetical that is related to some of the questions that Judd and Larry were asking. So in Fulton versus City of Philadelphia, one of the arguments in that case was that it was an unconstitutional conditions case, because this is the case where there's the Catholic Adoption Agency that has objections to providing home studies for same-sex couples or unmarried couples. And the argument is, well, the government, if it wants to require that, it's government money, so if you can't perform that service, then you can't participate in foster care. And it's an interesting example where the baseline has shifted from what we had at the founding, the contractarian sort of norm, where if the Catholic Church wanted to go help orphans, they could without government regulation. And I think it's good that we regulate it now. But now it's not just that the Catholic foster agency couldn't have the money, but the money also operates effectively as a license, because then you can't participate in foster care at all if you don't have the contract with the government. There's a similar issue sometimes with religious universities. If they don't get the government contract, sometimes it has requirements related to abortion, sometimes it have other anti-discrimination requirements. They just can't offer the program at all, because the government contract comes with certain technology or the ability to provide certain research. And so it's there are some contexts where the baseline is such that if you can't get the government condition, then you just can't operate in the space at all. And I'm wondering if that to you is an example of duress that you talk about, or is that an equality situation? Is it neither? Because the interesting counter-argument that is raised in these cases, like Fulton, is equality is cutting the other direction, right? They're saying, if you let the Catholic foster agency participate in foster care but not play by the same rules as everybody else, then we have an equality problem cutting the other way. And I'm just curious what you do with some of those dilemmas.
Thanks so much. Chris, I don't have much of a dog in that particular fight, at least not in this paper, with regard to kind of the significance of provides for and the spending power. I'm trying to be agnostic as I can on which of those three plausible kind of textual sources one might make the argument for. Maybe, I don't know if that was more directed to Jack, but correct me if I'm misunderstanding the question. But yeah, I think you can make arguments of various strength for each of those propositions. I know there's kind of a big, vast literature on, what is the proper source of the spending power and what are the implications, right? So here I'm just kind of surveying the options without kind of trying to say this is the one and only, but just to try to point out what would be the implications if we pick one or the other. Adam, with regard to your suggestion regarding the necessary and proper clause in the 10th Amendment, whether the 10th Amendment really adds all that much to the analysis. And here, I think, again, I'm skeptical. I mean, the 10th Amendment, the pervading question, right, since McCulloch and others, right, is, to what extent does it really add anything to the enumerated structure we already have, right? Is it just a truism, right? Or, maybe just a truism with attitude, or as Gary Lawson calls it, right? I think the strongest argument you could get for the anti-coercion principle, in my view, as a limit on federalism, would be through the necessary and proper clause, perhaps, as informed by in conjunction with the 10th Amendment, to say that interfering with internal state functions in some way is an improper use of federal power or transgresses some, unenumerated structural principle of federalism, right? Or some principle of federalism revealed from the text, right? Now, and I think that's also the strongest grounding for something like the anti-commandeering doctrine, right? Now, and so, some would say, it's a very short step from no commandeering to you can't induce the same action through offering regulatory benefits or offering payment or other financial inducement. My sense is that there still is an important difference, right? That may seem a small step, but it's an important one, because again, I think the model I'm using for thinking about state-federal relations, which is to some extent kind of somewhat the model that was used in the founding era, somewhat the model used by others, is kind of, we're thinking about sovereignty, we're thinking about sovereign rights. What are the sovereign rights on the nation-state, international plane between nation-states, right? If you're going and saying to another nation, use your officers to enforce my laws, you can't do that, right? They'll just tell you no, right? Unless you want to use your military, you can't coerce them. But what you can do, there's no limit, there's no violation on you saying, I'll only give you this money, I'll only trade with you, I will only supply you some other benefit you would like if you cooperate in the enforcement of my law or my policy. So I think there's a gap there, right? We can argue about whether that gap is significant enough, but I do think it's a kind of, from my view, I think it's an important one. Stephanie, I think the Fulton case is a useful example as well. Off the cuff, and I haven't kind of thought deeply about this particular example, I think it would be difficult to put it in kind of the generic equality frame that I kind of describe in Part 2B. I think it's as I understand the kind of the program and the framework, if you want to participate in the adoption space at all in this framework, you have to comply with these conditions. So everyone is subject to the same licensing requirements. And then you would be, does the government have a legitimate reason for saying you can't discriminate against various kinds of couples, right? And if there were no countervailing religious objection of any kind, right? If you're just saying, I just want to because I want to, I don't think there would be much of a equality argument to say we can't discriminate, we can't cut off funding for the people who just don't want to. So I think to the extent there's a constitutional problem, to the extent there's a constitutional concern, it would come in through the lens of the Free Exercise Clause and our kind of commitment to religious liberty, and whether there's something about that commitment that entitles groups or individuals to act on their strongly held religious beliefs, not even if it is contrary to generally applicable state laws, right? So we've got the anti-Smith position. So.
We got all the questions in, and thank you, everybody, and thank you to the panelists.